Court does call the case. People versus Daquan. Is it Hardrick?
This morning's docket wastes no time. Multiple defendants, multiple plea deals, multiple dismissals, and Judge Simpson, steady and methodical, moving through each case like a conductor directing a courtroom orchestra. But beneath the routine rhythm of scheduling conferences and plea negotiations, real consequences are unfolding. We're talking stalking charges, domestic violence allegations, probation agreements, bond disputes, and in at least one case, a felony dismissed in exchange for a misdemeanor plea. Right away, we see how procedural missteps, like paperwork sent to the wrong correctional facility, can delay justice. That's not drama, that's logistics. And logistics matter. When someone is incarcerated and not produced for court, hearings stall, timelines shift, and victims and defendants alike remain in limbo. But what makes this docket especially compelling is the number of no-contest pleas. That's a legal move with strategic weight. It avoids trial, limits civil exposure, and still allows the court to treat the defendant as guilty for sentencing. So the question becomes, are these calculated decisions risk management or quiet admissions wrapped in legal caution? Stay with this one. The surface looks procedural. Underneath, it's negotiation, leverage, and accountability playing out in real time.
And then on behalf of people, Your Honor, under Natalie for Mr. Hardrick, who is not present, Your Honor, from no fault of his own. He is currently incarcerated at the MDOC Macomb Correctional Facility. It's my understanding a writ was prepared for the wrong facility. To that end, we're asking for an adjournment of the final settlement conference.
All right. I will adjourn jury final settlement conference to, what's my next date?
June 6th at 9 a.m.
June 6, 2025, 9 a.m. Jury selection will be June 9th.
Yes.
June 9th, 2025 at 8:30. Both of those proceedings are in person.
Thank you.
Bond continue. Court does call the case. People versus Anatoly Zabrisky, I think it is.
Cool. And then on behalf of the people, Your Honor.
That's what I said.
It is.
I said it right.
You did. It's my ears.
Oh, okay. I thought you were criticizing my pronunciation.
Assistant Public Defender Natalie Davis, on behalf of Mr. Zabrisky, who stands to my right. Please state your name for the record.
Anatoly Zabrisky.
That's exactly what I thought. Isn't it, Alan?
Yeah.
All right.
Thank you, Your Honor. Thank you that you signed up for final settlement conference. I believe the case is also on this docket.
Yes.
My client will be entering a plea to resolve both cases. He will be pleading no contest to the misdemeanor case, and in exchange, the felony case will be dismissed.
Here's where things shift from routine to strategic. The defendant pleads no contest to stalking, a misdemeanor, and in exchange, the felony case disappears. That's not accidental. That's leverage. A felony conviction carries long-term consequences, employment barriers, housing limitations, firearm restrictions. By resolving the case at the misdemeanor level, the defense avoids lifelong stigma. But it doesn't mean this is a free pass. 5 years probation is significant. That's long-term court supervision. That's compliance monitoring. That's the risk of jail if probation terms are violated. Notice how both sides confirm the agreement carefully on the record. Every detail must be crystal clear, because once the plea is accepted, it's binding. And here's the legal nuance. Stalking, even as a misdemeanor, can carry serious reputational and relational consequences. The court is ensuring a factual basis exists before accepting the plea. That's critical. The judge cannot simply accept a plea without confirming that evidence supports the charge. So ask yourself, if you were facing both a felony and a misdemeanor, would you take this deal or roll the dice at trial?
That's correct, Your Honor, and there's agreement that you will be doing the 5 years of probation on this two case. That is
So he'll be pleading no contest. I have reviewed that report to the stalking that's in 0330. And upon that case, the case ending in 1211 will be dismissed.
That is correct, Your Honor.
Right. And there's an agreement to 5 years probation.
Yes.
May I have him sworn?
Right. You solemnly swear to affirm the testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God. Yes, sir. Thank you, man. Anatoly Zabrisky.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of stalking. Is that correct?
Yes, sir.
All right. That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs and up to 5 years probation. Do you understand that?
Yes, sir.
Do you understand what a no contest plea is? All right, two things about it I have to make sure that you understand. The first thing is that it, first of all, means that you're not further desirous or wanting to contest this charge. Do you understand that?
Yes.
The second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
This is the key distinction the judge is carefully explaining. A no contest plea does not mean I'm innocent. It means I'm not contesting the charge. But for sentencing purposes, it functions exactly like a guilty plea. The only real difference? It can limit exposure in a potential civil lawsuit. That's why we hear basis for the no contest, civil liability. If there's a parallel civil claim, harassment, emotional distress, damages, this plea prevents the defendant's criminal admission from being used as automatic proof in civil court. Judge Simpson methodically walks through rights being waived: right to trial, right to confront witnesses, right to appeal as of right. This isn't just formality. Courts must establish that pleas are knowing, voluntary, and intelligent. If that foundation isn't airtight, and the plea could later be challenged. And notice how calm and structured the judge is. No pressure, no theatrics, just confirmation after confirmation. That protects the record. This may feel procedural, but it's constitutional law unfolding in real time.
All right, basis for the no contest plea.
Potential civil liability, Your Honor.
All right, so, sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form today, is that correct?
Yes.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights contained on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea? Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes.
of your own free will?
Yes.
And because you believe, well, I won't ask that. Court has been provided Pittsfield Township Department of Public Safety report for their case number 2403852 or 853, excuse me. Any objections to the court having reviewed that report?
No, Your Honor. Nothing, Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of that offense. Counsel, have I complied with the court?
People are satisfied, Your Honor. Yes, Your Honor.
All right, court will accept the defendant's plea of no contest to that charge. The case ending in 1211 is dismissed pursuant to the plea agreement. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
April 21st at 1 p.m.
April 21st, 2025, 1 p.m.
I briefly address bond a little bit.
Sure.
Your Honor, I do understand that sentencing is set for pretty soon. It's on the 21st. We are respectfully requesting the court would consider modifying bond to a PR in this case. My client does state to me that he does have the support of his mother and that he has a FOC issue in Lenawee County he would like to take care of. With respect to requesting the court would consider a PR bond at this time.
Now we see the defense pivot. After securing the plea, they immediately request a bond modification. A PR bond, the personal recognizance, would allow release without posting additional money. The argument? Family support and a separate court matter to address. But Judge Simpson declines, at least for now. And this is important. The defendant hasn't yet met with probation for a pre-sentence investigation. That report informs sentencing and risk assessment. Judges rely heavily on it. Without it, altering bond conditions could be premature. This reflects judicial caution. Bond isn't just about convenience. It's about public safety, compliance history, and flight risk. Notice the balance. The judge doesn't shut the door completely. He says he'll revisit it after probation speaks with the defendant. That keeps things measured. And would you release someone before a probation review or wait for more data? That's the tension here between efficiency and responsibility.
Okay, I'm not going to need a response. I'm not going to change the bond until such time as at minimum probation has talked to him. So I will look at it after that. All right,
Understood, Your Honor.
All right.
Thank you very much.
thank you. Bond continue. Court does call the case of the People versus Nicholas Minahan.
And then on behalf of the people, Your Honor.
Good morning, Your Honor. Jeremy Glenn, on behalf of Mr. Nicholas Manning, standing to my right.
Nicholas.
I thought that was you over there.
Yeah, I'm here today.
You know, it's been a long time.
I like spending my Friday mornings with you, Your Honor.
Is that what it is?
It is.
He doesn't call, doesn't write, no phone calls, no. Anyway, what are we doing?
We have reached a plea in this matter. Mr. Minahan will be pleading to one count of domestic violence, no contest, under 769-4A. We've also reached an agreement as to the no contact provision. We agreed to no unwanted contact to facilitate parenting exchange between the parties after the no contest plea.
And that's correct.
Okay, gotcha. All right. May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth?
Nicholas.
All right. Sir, it is this court's understanding that you're going to plead no contest to the charge of domestic violence. Is that correct?
Yes.
That is a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. Do you understand that?
Yes.
All right. Do you understand what a no contest plea is?
Yeah.
Two things about it. I have to make sure you understand it. First of all, it means that you're not further desirous or wanting to contest this charge. Do you understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. Sir, to that charge, how do you plead? Now you understand that by pleading no contest, you will not have a trial of any kind. All right. You signed an advice of rights form today, is that correct? Any questions regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those, or pleading no contest, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plea? Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 248566. Any objection to the court having reviewed that report?
Oh, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's no contest plea to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be May 5th, 2025, 1 p.m.
And Your Honor, if possible, may I ask the court if I could appear via Zoom that day? I will be out of town in Maryland, actually, with my wife.
I don't think he's going to be in Maryland. I think he just said that because
I really will be.
I think he said that just so I might say yes.
I may have seen the Terrapin mug sitting there, but I.
Yeah. Okay. All right. Yes, we can. There's a form that you have to fill out and just submit it to us. We'll take care of that for you.
Thank you, Your Honor.
All right. Okay. So, and then as to the bond, I will amend the bond condition to. So my understanding is it will be no non-consensual contact for purposes of child exchange.
Yeah, and the co-parenting.
Just the co-parenting. Okay, is there a circuit court or family court order regarding that, or?
There is not, to my knowledge, there's a PPO that's expiring in the very near future, a couple weeks.
Okay, so the PPO says no contact.
Correct.
Does not give a exception for.
Correct, and that expires, do you know the date? Early May, I can confirm that date with the court.
Early May?
Yeah.
Okay, so even if I were to order it, I think the more restrictive order is going to apply. And so he would be, I don't want to put your client in a position where he's following my order and then violating the PPO.
Right.
So what I will do is I will grant that because the parties agree to that. However, I will not sign an order to that effect till after the expiration of the PPO.
This is a textbook example of judicial precision. The defense wants modified contact for co-parenting. The judge agrees in principle, but there's an active protective order. And here's the key. When two court orders conflict, the more restrictive order governs. If Judge Simpson were to authorize contact that violates an existing protective order, the defendant could unknowingly commit a new offense. That's how people end up back in jail despite following one judge's instructions. So what does he do? He delays signing until the protective order expires. That's careful, responsible judging. It's subtle, but this moment shows how layered the legal system is. District court, family court, personal protection orders. They overlap. One misstep creates chaos. Legal procedure may look slow, but this is why precision matters.
Thank you.
Okay, so
Follow up with Ms. Welding, with the date of the expiration.
yes, once. So you can do it one of two ways. You can submit an order to the court now indicating that it will go into effect once you figure out the expiration date, or you can wait till the expiration date, submit an order to the court, and I'll do it. So either way you want to do that. All right, fair
Thank
enough.
you, Your Honor.
All right, thank you. All right, enjoy Maryland.
Thank you.
Everybody's gonna get up here thinking I'll get my way if I just say that's where I'm going. Court calls the case, People versus Anthony Nett.
And then on behalf of the Your Honor,
Yes, he's in charge.
Good morning, Mayor. Please, Court, Your Honor. I'm Damien Cash on behalf of Mr. Anthony Ned, who is appearing in the court with me via Zoom by permission. Mr. Ned, state your name for the record.
Sir. All right, what are we doing?
Now, now that the prosecutor proceed, is there enough to go forward with charges?
Your Honor, at this time, people are unable to speak.
Do you have a motion, counsel?
I do have a motion, Your Honor. My favorite motion. Your Honor, without being able to confront the accuser, I have motion to dismiss this matter.
Now we see the other side of the system. The prosecutor cannot proceed, likely because the complaining witness isn't present. Defense immediately moves to dismiss, and the judge grants it, without prejudice. That phrase matters. It means the case can be refiled if the prosecution later secures the witness. This is constitutional. The Sixth Amendment guarantees the right to confront one's accuser. If the prosecution cannot present evidence or testimony, the case cannot proceed. Period. Some viewers might think that's a technicality. It's not. It's foundational. The burden of proof is always on the state. Do you think cases like this should be permanently dismissed when witnesses don't show, or is without prejudice the fair middle ground?
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Your
All
Honor.
right, thank you.
You
Thank
are
you,
free-
Mr. Ned.
Thank you.
Court does call the case of the People versus Franklin Fisher.
And then on behalf of the Your Honor,
And please confirm Your Honor, Robert Hamburger, car number P14570. To my right is Franklin Fisher.
All right. Sir, state your name.
Franklin Fisher.
All right, what are we doing?
Your Honor, at this time, people are unable to.
You have a motion for me, sir?
Yes, Your Honor, I would move to dismiss.
All right. People being unable to proceed, this case is dismissed. That's without prejudice. All right, thank you.
Thank you, Your Honor.
Thank you, sir. Court does call the case, People versus Stephen, is it Grisbeck or Grisbeck?
Defer to the court, Your Honor.
And then on behalf of the people, Your Honor,
Good morning, Your Honor. Sam Bernstein with on behalf of Mr. Grisbeck.
Your name?
Stephen Grisbeck.
Thank you.
We are doing the opposite of Mr. Cash's favorite motion this morning, Your Honor, which is we're going to be pleading guilty.
Okay, pleading guilty to the charge of domestic violence. Has he signed an advice rights form?
It's not, Your Honor. We went over that, but I will have him sign one.
All right, may I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony about the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Stephen Bridger.
All right, sir, it is this court's understanding that you're going to plead guilty to the charge of domestic violence. Is that correct? That is a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. Do you understand that? Understanding of?
Here's a second concern.
You're correct. So, you'll be pleading to domestic violence second offense. That's a misdemeanor punishable by up to 1 year, $1,000 fine plus court costs. You understand that, sir?
This escalates quickly. Domestic violence second offense increases potential jail from 93 days to up to 1 year and doubles the maximum fine. Prior convictions matter. Repeat behavior triggers enhanced penalties. Judge Simpson carefully confirms the prior conviction date. That's required for sentence enhancement. The record must clearly establish the earlier conviction. When the defendant admits intentionally pushing someone and confirms a shared child, the court is building the factual basis. That admission locks in accountability. Repeat domestic violence cases raise broader policy concerns. Recidivism in intimate partner violence is statistically significant. Courts often use probation and mandatory counseling to intervene before escalation becomes lethal. But here's the hard question. Does probation meaningfully reduce repeat offenses or merely postpone them?
All right. In understanding that, you still wish to plead guilty? All right. To that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct? Any question regarding any of those rights? Look at paragraph 5, you'll see it on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record, which is not anything, to get you to plead to this charge? Anybody threaten you or coerce you? You're doing this voluntarily, of your own free will, and because you believe that you're guilty of this offense? All right. September 2nd, 2024, at the location of 3121 Scenic Lake Drive, number 14, Pittsfield Township, Washtenaw County, State of Michigan. What did you do regarding a Samantha Smith that makes you think that you're guilty of this offense? All right. And who is Miss Smith to you? Okay, so you have a child in common? All right. And you did that, the push was intentional, is that correct?
Yes, Your Honor.
All right. And had you previously been convicted of a similar offense on or about May 24th, 2021?
Yes.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied. Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be April 21st, 2025, 1 p.m.
Your Honor, I know I saw the bond argument like just before mine, and I probably take some cues from that similar situation. It seemed like,
But you're not going to do that, right? No, go ahead.
modify at least what I was going to say. We're hoping for release after he speaks with Miss Polara. He's been in jail now for 2 weeks and a couple days, and
Okay, so when probation gets down and speaks to him, they'll be able to give me some additional information to help me make the proper recommendation. The other thing that should be noted is his sentencing is about 10 days away.
Sure.
So,
And Your Honor,
yes.
people also wanted to add, if he is released, we would also like to add the victim's place of employment to the no-go to the bond conditions, if it's not already. I believe she changed her place of employment, what was originally on.
Did they give, well, on the original order, does it just say place of employment or does it give a specific address? Because it should be a general.
On our no-go to, at least on our bond form, it was only her residence.
Oh, it was only a residence. Okay, so at this time, what I will do is I will add to his bond condition, no go to victim's place of employment. All right, so I'll add that at this point, so that way if he's released, that will also be applicable. You understand that, sir? All right, very good. All right, thank you.
Thank you.
Court calls the case, People versus Jeffrey McCullough.
That's a lot of good people.
Oh, hold on. Are they there yet? Oh. Good morning again. All right. Where are we on this case?
You're here this morning for a final settlement conference, but decided people are unable to proceed.
All right. People being unable to proceed. This case is dismissed. That's without prejudice.
Thank you, Your Honor.
Court does call the case of People versus Jacob Spelling.
That's a lot of good people. Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Spellings. Mr. Spellings, please state your name for the record.
Jacob Spellings.
The owner, there is an outstanding offer in this case to plead to an added count 3 of operating while intoxicated first offense. I also understand the defendant is willing to stipulate to a bench trial, as are the people, so we're looking for a bench trial date, and that offer will be held open to the date of the bench trial.
Okay. Did he sign the form?
Yes.
All right.
Wait, I didn't.
Figures parody.
I know.
All right.
Really, I did see the form. I signed it. I knew you were.
Okay.
So.
Sir, you signed this waiver of trial by jury form?
Yes.
All right. You understand that you have an absolute constitutional right to have the matter tried before a jury?
Yes, sir.
All right. You understand that by signing this form, you're waiving your right to that to be tried before this court without a jury present?
Yes, sir.
All right. People also, for the record, waive their right.
We do, Your Honor. I have signed the form.
All right. Based upon the statement of counsel and defendant, court will consent to have the matter tried before it without a jury. Non-jury trial in this matter will be set for.
And Your Honor, I neglected to mention too, that waiver did come with a stipulation from defense to the foundation admission of the blood results. We don't have to bring in the nurse who drew the blood, nor the witness from Michigan State Police Lab.
All right. Very good. Is that correct?
That's correct, Your Honor, and the people are gonna keep the offer open. And I'll be sure to communicate with Ms. Swanby if things resolve.
All right. Non-jury trial, April 30th, 2025, set 9 a.m.
Yes.
9 a.m.
Thank you,
right.
Your Honor.
Thank you. Bond will continue. Court calls the case, People versus Tanae Wright.
That's the line for the people.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Wright. Ms. Wright, please state your name for the record.
Morning.
Your Honor, today we are set for final settlement conference. The defendant has proven to me that she's completed a parenting course, and people are going to be dismissed in this case.
No objection.
This is one of those moments that shows the court's rehabilitative side. The defendant completes a parenting course, the prosecution has no objection, and the case is dismissed. No conviction, no lingering probation, no judgment entered. That outcome is not accidental. Courts often build compliance-based off-ramps into lower-level cases, complete counseling, complete a course, demonstrate effort, and in return, the state steps back. Notice the exchange, a little humor between counsel and the judge, but underneath that, there's recognition of advocacy. Defense counsel pushed, the client complied, and the prosecution agreed. That's the system working as designed. Dismissals like this don't make headlines, but they reflect a critical principle. Accountability doesn't always require punishment. Sometimes it requires proof of correction. The real question is whether these diversion-style outcomes actually reduce repeat court appearances, or simply clear dockets efficiently.
You don't have an objection?
Absolutely not.
All right.
I'm gonna see you online in person.
Wow. Should I? I should take offense at that, shouldn't I? No?
I think it's a compliment.
Is it?
Yeah.
Of course you're going to say that. You're the quintessential advocate, Ms. Graham. All right. This case is dismissed. All right. Good luck to you. Court does call the case of the People versus Travis Oliver.
Alexander, on behalf of the people, Your Honor. Assistant Public Defender Natalie Kate with on behalf of Mr. Oliver, please approach the podium. State your name for the record, sir.
Thank you.
Thank you, Your Honor. At this time, we wish to set this case for a bench trial.
All right, is he signed off on the
He
form?
has, I did turn it.
Did you turn it into a summary? You have. All right. Sure. Okay. All right. Sir, you signed this waiver of trial by jury form? You understand that you have an absolute and constitutional right to have the matter tried before a jury? You understand by signing this form, you're waiving that right to be tried before the court without a jury present? People also, for the record, waive their right.
Yes, Your Honor.
Based upon the statement of counsel, and defendant court will consent to have the matter tried before without a jury. Non-jury trial in this matter will be set April 30th.
Yes.
April 30th, 2025, 9 a.m.
We're seeing a pattern today. Multiple defendants waiving jury trials and opting for bench trials before Judge Simpson. That's a strategic decision. A jury trial introduces unpredictability. Jurors bring emotion, perception, life experience. A bench trial narrows the focus strictly to law and evidence. Attorneys sometimes prefer that when the case hinges on technical interpretation rather than credibility theatrics. Notice also how cleanly the judge confirms the waiver. The right to a jury trial is constitutional. Waiving it must be knowing and voluntary. Once waived, it cannot casually be undone. Bond conditions remain in place, meaning the defendant stays under court supervision pending trial. That preserves accountability. This is procedural discipline. Quiet, controlled, strategic. And here's something to consider. If your case depended on a legal technicality, would you want 12 opinions or one judge trained to analyze statutes?
Bond with its conditions will continue.
And I'm sorry, there was an offer that defendant for Plea charge with sentencing of a prosecutor, or that will remain open until trial.
Trial.
So that was our understanding.
All right.
Thank you.
Very good. Thank you. Court does call the case People versus Chiffon Hay.
After allowing the people.
Good morning, Your Honor. Assistant Public Defender Will hearing on behalf of Ms. Hayes. Your Honor, Ms. Hayes is on her way. She got a little confused. She did come last week and then she mixed up her days. So she is on her way. This is going to be a dismissal. So I'm asking sincerely if the court will consider passing it.
Your Honor, I know that she was present in Judge Barr's court on Wednesday as a victim, so it is possible she didn't mix up the case.
Oh.
Did you already get the sticker out?
Yeah.
Oh.
I saw a pair and he looked like, oh no. So I said, fine.
Thank you, Your Honor.
Thank you, Your Honor.
You don't mean it, Barony. No, you don't. Court does call the case People versus Kyle Smith Blue.
And then I'm back. Assistant Public Defender Natalie. States to my right. State your name for the record, sir.
All right. What are we doing?
Thank you, Your Honor. There's a resolution in this matter for my client, which is pleading no contest to the charge of MDOB under 200 under a prosecutor's deferred. And that's correct, Your Honor.
Less than 200. The 93-day offense.
Yes, Your Honor.
And then also a prosecutor's deferred.
Yes, Your Honor, correct.
All right, may I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony about to give the truth, the whole truth, and nothing but the truth, so help you God? Raise your name. I, Steve Blue.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of malicious destruction of a building less than $200. That's a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court costs. The fine could be increased at 3 times the value of the property destroyed. If that's greater than $500, that becomes the maximum fine. You understand that?
Malicious destruction of property under $200 may sound minor, but the statute carries up to 93 days jail and fines that can reach 3 times the value of the property damaged. That 3 times multiplier is important. It allows the court to scale punishment proportionally. This is also a prosecutor's deferred arrangement. That suggests the charge could ultimately be dismissed if conditions are met. Deferred agreements are accountability tools without permanent conviction, provided the defendant complies. Again, Judge Simpson carefully walks through rights, voluntariness, and factual basis. It's repetitive by design. Every plea must survive appellate scrutiny. When count 1 is dismissed and count 2 proceeds, that's negotiated narrowing of exposure. property crimes often stem from impulse, anger, or dispute. The court's role is balancing restitution, deterrence, and proportional punishment. Is a deferred resolution enough to change behavior? Or does the absence of immediate punishment reduce deterrence?
All right. Do you understand what a no contest plea is? All right, two things about it. I have to make sure you understand it. First of all, means that you're not further desirous and wanting to contest this charge. You understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. Sir, to that charge, how do you plead? Now, you understand that by pleading no contest, you will not have a trial of any kind. You signed an advice of rights form, is that correct? Any question regarding any of those rights? All right, look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading guilty or pleading no contest, you'll be giving up those rights as well as all the rights on the form. You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily and of your own free will. Court has been provided and has been able to review Pittsfield Township Department of Public Safety report for their case number 208292. Any objection to the court having reviewed that report?
No, Your Honor. No, Your Honor.
Based upon a review of that report, the court does find that there's sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
People are satisfied, Your Honor. Yes, Your Honor.
Court will accept the defendant's plea of no contest to this charge. That being the count 2. Count 1 is dismissed. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
May 5th at 1 p.m.
May 5th, 2025, 1 p.m. All right.
Your Honor, may I briefly address an aspect as to bottom?
Sure.
So Mr. Kyle Smith Blue has some family in the Chicago area. Your Honor did previously sign a stipulation order that for some specific dates that he could travel to visit family. He is asking that pending sentencing, he be allowed to travel to Chicago to see family back and forth.
He likes his family?
I believe
No,
it does.
I'm kidding. All right. Any objection from the people?
No, Your Honor.
All right. Why don't we do it this way? I don't have a problem with him traveling to Chicago to see his family. Just prepare an order to that effect. I'll sign up.
Absolutely.
All
Thank
right.
you, Your Honor.
All right. Thank you. And I hadn't said this to the other individual. Make sure to stop down at probation on your way out there on the left. Okay?
Thank you, Your Honor.
Court does call the case People versus Ariane Walker.
Good morning, Your Honor. After long, good people. Good morning, Assistant Public Defender Mark Perry on behalf of Mr. Walker. Mr. Walker, please state your name for record.
Thank you.
Your Honor, today's date time set for final settlement. We are ready to proceed. I do believe the defendant is going to be tendering a plea of guilty as charged to stalking and sentencing under the Home Youthful Trading Act. In exchange for that plea, the people will not pursue a potential bond violation that we learned about this morning from February. And that's it.
All right.
That's our understanding of the agreement, Your Honor.
All right. Let's have him sworn.
Do you solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth?
All right. Mr. Walker, it is this court's understanding that you're going to be pleading guilty to the charge of stalking. Is that correct, sir?
This is a layered negotiation. The defendant pleads guilty to stalking. In exchange, the prosecution agrees not to pursue a potential bond violation discovered that morning. Bond violations can complicate sentencing dramatically. They signal noncompliance. They undermine credibility. Avoiding that additional allegation is meaningful. Stalking, even as a misdemeanor, carries serious implications. The judge clarifies that it involved repeated following after being told to stop. That satisfies the course of conduct requirement under stalking statutes. It cannot be a single accidental encounter. The court also confirms whether a reasonable person would feel frightened or terrorized. That element is essential. Stalking isn't about annoyance, it's about fear. This plea closes the chapter on potential escalation. But the facts described, repeated following despite requests to stop, raise sobering concerns. Where is the line between persistence and criminal conduct? In stalking law, it's crossed when fear becomes foreseeable.
Okay. Now, that is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs, and up to 5 years probation. You understand that? Okay. Understanding all of that, do you still wish to plead guilty? And to that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct? Yes? I need you. All right. Do you have any questions regarding any of those rights? Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? No? Okay. Anybody threaten you or coerce you? Anybody promise you anything that hasn't been stated here today on the record to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily and of your own free will. And also because you believe that you're guilty of this offense? All right. On the date of September 8th, 2024, at the location of Woodland Hills and Packard Road, Pittsfield Township, Washtenaw County, State of Michigan, what did you do regarding, is it your Danka Labrada that makes you think that you're guilty? Pardon? Well, what specifically did you do? Go ahead, Ms. Verity.
Did you, follow behind, the alleged victim in this case? Did you have her consent to do so? Would it be reasonable that she would be frightened or terrorized by that behavior?
Had there been previous contacts between the two of you?
Well, Your Honor, I know there's one date on that, but this happened over a period of time. So, Mr. Walker, do you agree that it was more than one day that you walked behind her?
Okay, so you're walking behind her. There had been repeated occasions of you doing that.
Here the record becomes crystal clear. The defendant admits multiple occasions of following after being told to leave her alone. That repetition is what elevates behavior into stalking territory. Intent matters. Consent matters. Context matters. Pain. And the judge methodically ensures each element is satisfied before accepting the plea. We also hear about bond conditions continuing. That means restrictions remain until sentencing. The court is not relaxing supervision. In stalking cases, courts often impose no contact conditions, counseling requirements, and structured probation to prevent recurrence. This is not a technical conviction. It reflects a pattern of conduct that frightened another person. The broader legal principle is straightforward. Once someone communicates a boundary, persistence can transform into criminal liability. That's the dividing line the court just reinforced.
All right.
And those were after she asked you to leave her alone.
Okay. That's the other thing.
I think the reasonable person, the only other thing.
Well, I think it was already asked by Ms. Parity. All right. Has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Of course, satisfied, Judge.
All right. Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be April 30th, 2025, 12 p.m. 12 p.m. Bond with its conditions will continue.
President, the court will permit, allow me to ask the defendant to stay in the courtroom for just a few moments while she leaves and gets
Yes.
out here. Thank you
Yes,
so
that's
much.
fine.
I'll ask Ms. Endler to
All
check in with Deputy Allen.
So, sir, you'll need to have a seat. Don't leave the courtroom until the court instructs you. All right. Either myself or through my bailiff. All right. Thank you.
What we witnessed today was not one dramatic explosion, but a series of calculated legal resolutions, multiple no contest pleas, several dismissals without prejudice, strategic bench trial waivers, protective order navigation, deferred agreements, and careful judicial oversight from Judge Simpson. The through line? Procedure protects everyone. Rights were explained, voluntariness was confirmed, evidence was reviewed, and where the prosecution could not proceed, cases were dismissed. That's constitutional balance in action. We saw how plea negotiations reduce felony exposure, how repeat domestic violence enhances penalties, how stalking requires repeated conduct and fear, and how probation reports shape sentencing outcomes. This docket reflects the dual purpose of criminal court: accountability and structured opportunity for correction. Not every case ends in jail. Not every dismissal means innocence. The system is layered, and each layer matters. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.